Hey, what's going on, you guys? What is going on today? What is today? Happy is Friday. It is an impromptu live. So I might not get a lot of people on here today. Um, as I always like to do before I start the show, I just want to make sure I'm live so I'm not talking to myself because, like I said, I might not get anybody on here because I know we typically go live on Sundays at 6:30 p.m. But I hope they're gonna go tease. But definitely tune in live on Sunday. We will have a home insurance agent on live with us on Sunday to kind of talk about home insurance. Today, if you guys know, I'm in Georgia, so with me being in Georgia, today is a snow day. It has snowed today, so I decided, which most of the state have decided, or depending on where you're at in the state of Georgia, we decided to stay in the house. My lips are very dry too. So needless to say, I figured why not have a conversation around probate, wills, and different things like that. Before we start this conversation, I just want to let you guys know I am not a probate attorney. I am not a lawyer. I'm not an estate plan lawyer, an attorney per se. So anything that we discuss today, just make sure to be mindful to take it to go and ask an attorney some questions, go and seek legal counsel if possible. And then also you can ask any of these questions you might hear on this live today. This particular information was actually given to us at our brokerage in regards to a probate attorney in the state of Georgia, where I'm currently located at. So again, laws, legalities in different states and stuff, they change. So I just want to let you guys know that even though we're going to be discussing this information, some of it may be generic information, some of it may be stuff in which you should seek legal counsel for. Hey, what's going on, Eddie? Hope you are staying safe and warm. Yes, and it's snowing over here in Georgia. Well, the snow has stopped. It's just sleeting right now down here. So, a lot of things are closed. So I figure why not do an impromptu live today and talk a little bit about probate. So I was just giving my spiel to let everybody know I'm not a legal attorney per se. However, I have experience in probate, and this information that was given to me around probate has been given to me from a probate judge in the state of Georgia. I got a lot of stuff all over my face. I probably should wash my face before I came on live. Was given to me, so I figured we would just kind of talk about this today. And like I said, told everybody, make sure you do seek legal counsel in the state that you're in. Every state is different in regards to what they do legally. But hopefully you guys are staying warm as well. I'm not sure how it's going in Louisiana, but hopefully you guys are staying warm. So, like I said, didn't figure I'd probably get a lot of people jumping on here today because typically I come on Sundays. But let's jump into it, and we'll talk a little bit about probate because I get this all the time from people. And I haven't seen it lately. And also, I'm dealing with a client right now who has gone through the probate process, and a lot of people are, experiencing this type of situation. We are wet and cold today. Okay. So you guys you didn't get no snow, just raining and cool down there. Well, at least you guys are, staying safe, and at least you guys are, you say you're cool, but at least you're not too hot and too cold. But I know that wetness can get you a little cold as well. But but yeah, that's if you guys want to stick around, please do. If you guys have to go, I definitely understand. But I just want to get this information out there and allow you to ask more questions. So the whole thing that I always tell people about real estate and about anything in life, you want to ask a lot of questions, just inquire about stuff. And it is my job as a professional in real estate to advocate and educate you guys. So I try to do my best. And remember, I am not a lawyer. However, this is information given to me from our local county judge in this county that I'm in Atlanta per se. She is a actual sitting judge right now on the probate court with the magistrate. She sits on probate court, and she gave us she came to our office. She spoke to us more in depth about probate because we've been seeing a lot of more probate things happening. And she also decided to print out a packet in regards to probate and different things about probate. So the first thing I kind of want to get into is what is probate? And hopefully, like I said, remember you guys want to, I think I lost myself on thing. Remember, you guys want to always consult with your attorney, an estate plan attorney, a probate attorney, any legality, because I am just a realtor. I am not a attorney. So we're talking about this stuff, but all this stuff is from the like I said, it's from a current probate lawyer. So I mean judge that sits on the probate courts. So hopefully, I'm not sure if you guys can see it, but what I'll do is I'll read it and we'll talk and we'll discuss. And if you have anything you want to say, please put it in the chat. If you're watching this on replay, please put comments below. If you have questions, my email is below. You can reach out to me. I can always, try to seek some answers for you because, again, I am not a lawyer or a judge in probate. But it basically says what happens in probate court. So it basically says probate is a legal term and a procedure of family's estate is required by law to go through after a person has died, leaving behind property. So it doesn't just result into just real estate. It results to like bank accounts, any type of assets that this person may leave behind. If people don't know this, that technically we all have an estate. Everybody has an estate. The clothes on your back, the shoes on your feet, they're considered an estate. So anything that when you leave this earth, any belongings you have, in place, is technically part of your estate. Does all of it have to go through probate court? Again, I'm not a lawyer, so I don't want to say yes or no. But I would think that if your mom had some clothes in her house and you want to donate or give it away, I don't know if that has to go through probate. I would think it doesn't. But when it comes to property transferring, real estate, those things you want to make sure that goes through the right legal transfer probate. All right. So it says during the probate, the court will appoint someone to manage the estate or of the deceased person. The person appointed by the court is called an executor or an administrator. So if you guys don't know that typically when you write a will in place, the person will put in the will who is the person to be the executor of the estate, and different things like who's basically going to control how the things are carried out going forward. And sometimes if that person is not already in place per the will written out by the person who might have passed, the court will actually assign an executor or an administrator. I have a lot of colleagues who have done some probate stuff as well. I would have loved to actually gotten my one colleague on there because she literally she is teamed up with a probate administrator, and he basically assigns her a lot of his probate properties. And maybe I'll try to get her next time. She's a little camera shy, but maybe I'll try to get her on there. But she does a lot of probate sales, and she because he's an administrator over certain states when they can't find either when the family's not getting along and they don't know who how to effectively sell said property, or if they can't find any heirs per se in place, then they'll kind of give it over to an executor or an administrator. And he's the lawyer, so he's just he administrates stuff. But anyway, the executor or the administrator is responsible for gathering the assets and handling the affairs of the estate. The probate court oversees all matters related to the estate of the deceased persons, including the following. I know it might be, if you guys can see this, let me know. If you're watching the playback, it's going to be too late to let me know. I've been trying to figure out how to make this a little bigger, but I can't make it so big on my computer. I don't know why. Maybe I could do this. There we go. I just zoom in like that. It says basically the probate court oversees all matters related to the estate of the deceased persons, including the following: holding a will for safekeeping, determining the legal validity of a will. So the court wants to determine that the will is valid. I don't know what is this. This must be a grade on my head, on my face. I know it's something right there. I don't know where. Sorry. Resolving disputes between heirs of an estate. Also deciding who should manage the estate, and supervising the management and distribution of the assets of an estate. So that is what the probate court typically does. They might do a little bit more, they might do a little bit less, but typically they kind of do these particular things right here. Again, every state is different. This is Georgia, so I just want to clarify that again. If you're in Georgia and you're watching the playback, put it in the comments. Let me know where you're at in Georgia. Hopefully this information can help you if you're going through something like this. If you're somewhere else, let me know in the comments as well. And I appreciate you guys coming over to this channel and joining me today. All right, so now let's go into the next part in regards to probate and wills and all those things. So most people don't know this, but even if a will is in place, you still have to probate a will. Most people don't know this because they think, oh, okay, the will is in place, I don't have to probate the will. it states X, Y, and Z here that blah, 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 blah. So they're like, I don't have to probate this will, but you still have to probate a will. Oh, sorry, my thing is. So what we're going to do, we're going to do like this. So this makes it a little bigger. Some of the words are cut off. Again, this is like I said, the judge provided me, gave us a pamphlet so we can, detail this to our people, anybody that's looking for any advice around probate, some basic information, some knowledge to hopefully get you down the right avenue. But anyway, it says probate is, says what is heir probate? So it says probate is the legal term and process completed when a person dies called a descendant. And then it's hard to see others over there, that basically they leave assets to distribute, such as bank accounts, real estate, belongings, financial investments. Probate is a general administration and distribution of a deceased person's last will or their estate of a deceased person without a will. Even though, I don't know if you guys can see, let me know if you can see this as I'm reading it down. Like I said, some of it's cut off, but let me know. Even though the heirs are current owners, because the deed of the property still has the previous owner's name on it, the property remains titled in the name of the deceased person. This situation makes it difficult for the family to use or sell the property. I gotta remember what this says over here, but I think it says the heir or the heirs must accomplish what is called the succession of property. That is, have the property basically retitled and placed in their names. Multiple heirs. Multiple heirs and rights and responsibilities. It says when heirs co-own property together, everyone has an equal right to use the property as well as equal responsibilities of homeownership. So once you guys are equally, say, heirs, they do want, like they said, equal right. It's equal as far as everybody has equal responsibility. So say if the house, your parents own the house, the property taxes still have to get paid on the house. Even if there's not a mortgage left on the house, property taxes still have to be paid on the house. You guys have the same equal responsibilities to split state property taxes accordingly and pay accordingly. Does it always happen? I've seen cases where no, it does not happen. It does not. Every child left might not be in the best position to actually pay said property taxes or pay that there's a mortgage left on the property. They're not in a, they don't have the best financial, I guess, assets per se, or any type of financial money, finances per se, to pay for any additional fees or things that have to be paid for in said property. And when this happens, sometimes another person will pick up that weight, and when they pick up that weight, this might carry out later on if you guys try to sell that property. That person might say, well, I paid all the taxes and I feel like, I pay all these taxes, that when we sell this house, I should get this back because I paid said taxes. And I believe when I was talking to the probate attorney that I know, they were basically saying that there's a way in which that can be played out when the money is distributed, where if you take care of a lot of the necessary things on the house financially per se, they can give you that back on top of what is distributed. What did Eddie say? Eddie said, what happens if the value of the estate is disputed? So yeah, the value of the estate, what do you mean as far as like the state, like the value of the house, or what are you talking about as far as the value of I guess a little bit, give me a little bit more, because I do know that people don't realize this, that when you do wills, which I didn't realize it either until I started going through this process. When you start working in probate and you go through these processes, you're like, you learn and you learn and you learn. That's the best thing about, when going through stuff, learn and learn. Like I knew the generic amount of some information in regards to probate prior to it because I've gone through it family-wise, but I wasn't fully in depth with it. But when you work with somebody else going through it, you find out more. But every will put in place has to be probated. Whether the will is written out for the last solemn testimony per se, or whether there's no or whether well, yeah, I was talking about the will. So every will has to be probated. So in regards to every will having to be probate, and I'll talk, I think it's more on the next page that I'll read too about it. With that happening, a will can also be contested. So I guess similar to like you say here, Eddie, where it says what happens if the value of the estate is disputed. So a will can still be disputed, they can still be contested per se. So what happens is that if a dispute happens and is contested, And if they can't come to a resolution of everybody that's inside that will, then the court will then assign another executor or administrator, someone that's basically a third party, to execute the last, I guess, words per se of said person who died who has the will in place. So say if you have a house and no one can come to an agreement, if they go to the courthouse, they have the will per se, and then everybody's there and they're like, well, I don't want to sell the house, well, I want to sell the house, I don't want to sell the house. Sometimes the courts are like, well, you know what, if you guys can't make a decision, we'll put a third party in place and we'll force the sale of the house. Like if you guys can't come to a decision, we'll just force the sale of it. And we'll put it in a third party's hand. We'll allow them to execute said sale, and then we'll distribute any value or any equity or any funds to you after the sale is made. So you don't want to do that. You want to try to come to a common ground and say, hey, let's just come to a common ground so we can bypass this probate situation. We want to go down to the courthouse. We want to file. We have to file it in probate, whether a will's in place or not. The only way that you can typically get around probate is having something in the trust sometimes, but also when the thing is in the trust, which I also found out through my probate attorney, is that when things are put in the trust, you still have to make sure that your probate attorney knows how to successfully put said properties and things in the trust. So a property has to be deeded into a trust. So if you don't deed the property into a trust correctly, then technically the property will still go to probate. So I always tell like people, because I have a lot of people that come to me now, like because the big thing is like a lot of more information is out there about trust and everything, and people are like, oh, I want to do a trust. I'm gonna put everything in trust. I'm like, okay, well, if you put stuff in trust, remember you have to deed your house to the trust. The trust is an entity. It's basically almost like a company per se. You have to deed the house into the trust, so the trust then owns the house. But if it's not deeded into the trust, it's like, what's the point? You're sitting with an attorney, and they're doing the papers for you for a trust. And you're like, okay, I want my house to be in a trust. And if the attorney doesn't know how to effectively deed said property into a trust, and they just let's just say in the documents, like it says like, and they put it on like line A or something, like they'll say like the house at blah 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 address, and this means that it's in a trust. No, it doesn't. It has to be officially deeded into the trust. And I know in Louisiana, sometimes they can find all their family members. They can't find all their family members. That's the causes a big mess. Yeah, it's actually something that one of my colleagues, and this is why I want to jump on here. I know she's working today because outside of real estate, she works for a leasing management company, and I know that she had some clients kind of going through that too. And we were talking about this, and I was like, you know what, it's slowing down here. I ain't got nowhere to go. We were talking about it the other day. I was like, why don't we just get online and talk about probate? Whoever joins. Whoever doesn't, hopefully they'll watch the replay. But we were talking about this the other day about probate, and so she called me because she knows that, you know, I have some knowledge about probate, and outside of me, another colleague of mine, well, a few colleagues of mine, we have knowledge around probate stuff. So she called me, and we were having this big discussion, and one of them were in regards to not being able, the person's house that they're trying to sell. Basically, most of the relatives had passed away, and they would need to, before they can effectively sell that house, the last person who I guess was the beneficiary or quote unquote person for the probate per se, they passed away. And so as far as like, you know, the way the succession goes as far as ownership per se out of probate, that person passed away, and so now they're like, she was coming to me, she's like, well, is there another way, you know, because the lawyers said, well, for us to go and dig up more family members and see who this would go to, it would cost about $2,500 to kind of get that process started through the probate attorney, and the person's like, well, I don't really might not have that right now to give for state attorney. Is there another way to effectively go through this process? And unfortunately, I was trying to give her some information because people don't know that you can still go down to the court system and file for probate. However, when it comes to like digging up other family members, people who are deceased and all that stuff, you're going to need an attorney. You're going to probably end up needing to get an attorney because you got to find where this is at. You're not going to be able to successfully sell said property, especially a house, without finding these other members. So yeah, it becomes a big mess, Eddie. Like you said, I know in Louisiana sometimes they can't find all their family members. I thought another thing about probate, which was crazy. I don't know where the video was at, about a man who had And it wasn't about even real estate. With this probate situation, with a man had like millions of dollars, like he saved millions of dollars somewhere. I wish I could find that video. It was a news clip. He saved like millions of dollars, and again, bank assets and all that stuff has to go through probate. Like me and my dad, and you know, my mom. So on my mom's side, there's 5 kids. My dad's side, he had 2 of us, and my mom. And in total, I have, you know, several siblings per se because they all came from my mom. But we have different dads. But so I always, because knowing this information, even when it comes to probating in assets and bank accounts, I, and everybody doesn't have to do this. This is just what I did. Okay. I recently when I went back to Jersey, I went up there, and because I wanted me and my dad to be on the same bank accounts. And the purpose of us being on the same bank accounts, because if people don't know, even when it comes again probating bank assets, accounts, and everything, you can be put on the bank as a beneficiary. However, which I suggest everybody do, if you have a parent, and this is just through me, you can talk to a lawyer, attorney, however you guys want to do it. But if you have a parent and they have a bank account and they're getting, you know, Social Security or all these different things or whatever, I believe Social Security can't come to you though, unless you're a disabled child of said parent, then you can get Social Security. But let's just say they're what's it called? What's it called when people retire and they have a, I forget, I don't want to call it retire. I don't know. You guys know. But basically, you know, he every month his money goes into his bank account. He has monies in his bank account. And so, unfortunately, we don't want to think of the thing of like parents passing away, but unfortunately, we know we live on Earth and we leave Earth, so we have to start getting things in order. So, in regards to that, you know, somebody's calling my phone. I don't know who. Somebody's calling my phone. Sorry, y'all. I'm going to put this on thing. Hopefully they'll call me back. I don't know who just called my phone. They call me in Jersey too. I don't know who it is. This is what happens. But anyway, get back to what I'm saying. It'd be funny if it was the bank. But in regard to this, my I guess I'll go back to the bank. My dad basically, I went to Jersey recently. I was trying to get him to do. We was trying to do it over the phone. So initially, he was able to go to the bank the first time. Because the first time I was like, okay. I was like, you know what, Dad? Just for right now, put me on the bank account as a beneficiary, just in case anything happens. Blah blah blah. However, with a beneficiary, you still have to go through things as well. Oh yeah, I'm looking for Stephen Clark. I don't know who Stephen Clark is. Sorry, y'all. Somebody just called me and then they just text me, said they're looking for Stephen Clark, and my name's not Stephen Clark. But that's my cousin's name is, but it's not me. But anyway, my dad initially put me on his bank account as a beneficiary, and then I was like, you know what? I still have to go through things even if I'm a beneficiary on a bank account. Like, yeah, I'm able to acquire said assets from the bank account, but I still have to go through other legal channels as a beneficiary on a bank account to get said, you know, funds out of the bank. When he, you know, hopefully don't leave no time soon, but when he does. And so I decided to go up to, so I told him, like, you know what, Dad, go on the bank and put me on the account, and let's do a joint account together, and this can stop when it comes to probate or whatever, as far as me going in and accessing the funds. And so, of course, when he went to the bank to try to do it, because I'm in Georgia, he's in Jersey, they were like, he needs to be here. So the banks require that you're there to put accounts together, blah, blah. So I had to go back to Jersey, get on the account together. But this just helps in regards to if anything happens, I don't have to go to probate to get access to the funds in the bank. You know, most people don't want to do this. You know, this is just my suggestion. If you have a spouse, you guys should always have a joint bank account. Even if you have your separate bank accounts, yeah, it's great to have separate bank accounts too, but you should always have a joint bank account to access anything. Say if you guys are on, if you are you have a house and the person passes away, but one of your spouses was always basically paying said bills out of their account or something, maybe you guys should form an account together and have that bill money just come out and maybe just put the bill stuff in that account. I don't know. I'm just trying to give you guys some leeway, because when you guys start getting in depth into this whole legal stuff, this probate stuff, and like I said, for me having experience and me learning different things, it's a mess. Like Eddie said, it becomes a big mess. It's a mess. So I'm doing stuff purposely and trying to be proactive instead of reactive, because we don't know when people leave this earth. So we need to start putting stuff in place because we don't know when someone leaves. So that's just my opinion, my suggestion. Everybody, please move how you move in life. That's just me talking. Okay. Anyway, let's get back to probate, because I'll tell you about my whole life. And yeah, I do a lot of stuff that's people probably like, why are you doing all this? But anyway, it says it says as well as equal responsibilities of homeownership. This is true in regard of who actually is living on the property, who's taking care of it, who is paying the bills, etc. All heirs are legally equal as co-owners, equally liable for any utilities, property taxes, and mortgage payments. All right. So up here it states, if you guys can see, it says warning: avoid losing the heirs' property. It says heirs' property is unstable. It's an unstable form of ownership that limits a family's ability to access the equity in their home or land. Without clear, definitive title, heirs' property owners face an increased risk of forced sale and eviction, which is another thing that one of my colleagues was talking to me about. And like, I was hoping she would be on here or send her people over. I know we got on a three-way call. I've been on several three-way calls with people who called me about probate stuff, just because, again, kind of living in some of this space. They call me and we have three-way phone calls all the time. So that's why I'm making this video. So then going forward, I can just send the video to them. I don't mind jumping on calls because, like, again, I like to educate and advocate for people. But after a while, people are like, I'm saying the same thing over and over. Let me just make a video about it. It says, so this is what happens is, without clear definitive title, heirs property owners face an increased risk of forced sale and eviction. It says they cannot qualify for local home repair programs funded by HUD programs like CDBG, and CHIP. So again, this is about Georgia, right? So every state is different. So I would definitely, again, talk to the attorneys in your state, figure out different things, but you want to effectively go through probate, because when you effectively go through probate, it gives you rights to do some of this stuff. So this is saying, like, if you don't go through it, this is what you cannot possibly benefit from, right? It says cannot leverage bank finance for improvements or business investments. So say the house needs to be improved and you want to all of a sudden take out a HELOC or anything, or pull cash out of cash equity, advance, all these different things that people do in their houses. If you want to pull stuff out, in order to repair things, pipes burst, blah, 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 and you don't want to go through home insurance. Again, Sunday, I'll have a home insurance agent on. If you guys please join me so you can have questions, ask her questions. Hopefully she sticks to say she's going to join me. We've been back and forth via email, so hopefully she'll join us. But I have a lot of questions when it comes to home insurance, and hopefully I don't catch her off guard. But I gave her a list of questions, but hopefully I don't catch her off guard, because we got to make sure we're using our home insurance effectively, you guys. Especially what's going on now with all these disasters and inclement weather situations. It's a lot. And homeowner insurance dropping people and different things. So anyway, cannot fully access farm, timber, easement programs offered by USDA, Georgia Forestry Commission, and the Georgia Department of Agriculture, are ineligible for FEMA assistance and have difficulty accessing disaster recovery programs, may not qualify for homestead exemption to reduce property taxes, cannot sell, mortgage, or lease the property without heirs' unanimous agreement. So those are some things that you cannot do if you don't effectively go through probate. Let's go to slide number 3. There's 9 slides here, so hopefully I'll take up everybody's time if you're joining me today. If you're watching a replay, please put in the comments where you're watching from and how you found the channel. And I appreciate you coming over here. Don't forget to like and subscribe to the channel as well. Definitely subscribe. And hopefully, this information help you and you'll still be able to utilize it and go to a legal attorney per se. So now let's talk about how it works. Again, this is how it works in Georgia. Every state might be different, but typically succession, or the way in which this is all based around real estate, right? Even though in the beginning it kind of talked about it's going to base it on real estate as far as this discussion, because I'm a realtor. So we'll base it on real estate, and then you'll talk to the legal attorney and they'll tell you how it kind of passes per se in any other entity. Anyway, so when it comes to how do I know if I co-own heirs property? So in Georgia, this is telling you how it passes and then what happens when it passes. So it says Georgia interstate succession. So basically you have intestate, you have intertestate. So intertestate, I gotta remember myself. I believe that's when you have a will in place. And then when you don't have a will in place, I think it's testate. I gotta remember. If I'm wrong, my lawyers or my realtors correct me in the comments to make sure everybody gets the right information. He said, "You're the best." Oh, thank you, Eddie. I appreciate it. I try to do my best. He said, great information today. Thank you, no problem. I appreciate you joining me. I appreciate you commenting. You know, I think you and a couple other people that are dipping in and out, probably the only person watching me today because, you know, it's a Friday. And I was like, let me just jump on. I ain't got nowhere to go. It's snowing outside. Yesterday, I met a potential client to sell their property, but we had a good conversation. That's probably another video I can make about people who just buy their property and they're trying to sell it already. We had a great conversation. I took another colleague of mine. One thing about me that people probably don't know, and they probably like, why do you do this? When I get opportunities to sell people's properties, I always bring a co-agent on with me. And I do that all the time. I don't mind sharing my money in real estate. I don't care. Money comes and goes, and I don't think people realize that. So I always put a co-agent on for me because I don't have a team, but I do partnership, right, with co-agents out of my brokerage. And I bring them on with me for a lot of purposes. One, because two minds are better than one. And in this situation, you're the seller, so we have three minds. You know, four eyes is better than two. The seller looking out of their own eyes, but from our perspective, my eyes can only give us so much. And then you have more, you might have information in space, I don't have information, and vice versa or whatever. And then we learn together. So I don't mind bringing on other agents, but that's a whole other story. We met with a potential seller yesterday that he wants to sell, but unfortunately, I don't know. We'll see what happens. You know, we can't predict what happens in the future. Nonetheless, let me get back to what I'm talking about because I'll go off the topic and tangents a lot. So it says, if you pass away with children only, then this is what happens in the state of Georgia, typically with your estate stuff, everything to children equally. So if all you have is children and you pass away, everything goes to your children equally. It says if you pass away with only a spouse in place, everything goes to your spouse. And if you pass away with a spouse and one child in place, half of it goes to the spouse, the remainder goes to the child. If you pass and there's a spouse and children, 1/3 of it goes to the spouse, the remainder goes to the children. If you pass and there's no spouse or no children, everything goes to the parents in Georgia. If you pass and there's no spouse, children, or parents, everything goes to the siblings. And then so on and so on. If you pass, they didn't kind of go deeper, but it all gets distributed in different ways. So let's go down here. I gotta try to make it bigger so y'all can see what I'm reading. It says, if the owner named on the last recorded deed for the property dies without a will, the property passes to their heirs at law pursuant to the Georgia Code for intestate succession. This means a spouse, children, grandchildren, siblings, parents, or nieces and nephews hold an ownership interest in the property. So that basically everybody owes an ownership interest in the property because all right, so let's see. It says if the owner named on the last recorded deed died without a will left for the property, without a will to the property, left to the property to two or more beneficiaries. Rewind them on, slow down. So basically, if the owner named on the last recorded deed died with a will, it's with a will, not without, with a will, they left the property to two or more beneficiaries, for example, multiple children, ownership is fractured and may continue to divide as the original beneficiaries pass away. So basically, if say like my dad, his mom, my grandmom had a house with my grandfather. My grandfather died. They were married together. The house passed to my grandmom because she was still alive. So they were in Pennsylvania. So again, the way succession goes, it might be across the board because even in Georgia, it says the same thing. Like it says spouse, everything. Right here, spouse, different spouse, and then children per se. But but also people got to remember how it's a lot even behind the probate part too. You have to kind of go into like deeds and tenants in common. Like in Georgia, we have like tenants in common, joint tenants in the right to survivorship. So then everything breaks down accordingly. In Pennsylvania, again, I don't know how exactly it kind of correlates, but I know with my grandpa, back in the day, he bought 2 lots in Pennsylvania. He built a house for $25,000 on a lot. I think I talked about this before. So the house was on one lot. It was our whole backyard was on the other lot at my grandparents' house. My grandfather passed before I think he passed even before I was born. I think he passed when my dad was like in his 20s, and I was born when my dad was in his 30s. So my grandfather passed on my dad's side. So I never met my grandfather on my dad's side, but I met my grandmom. But when my grandfather passed away, my grandma and my grandfather, they were married. And so probably in the way in which they took deed, probably was able to give my grandma the right to the house per se, because typically that's how it works too. Because if they're both on deed, and if you have a certain deed set up, it'll go to the person on the deed before you go through this whole probate situation I'm talking about. But so she had the house anyway. My grandmom died, but people didn't know this. But of course, I'm Inspector Devon. So my dad didn't even know. Like none of the kids noticed, but my aunt, before my grandmom died, even though she had a will in place, my aunt actually did a quick claim deed of the house and put it in her name. And so technically my aunt owns the house through that, even though technically people don't realize that's considered a break in the title. Again, I'm not a lawyer, I'm not an attorney, I'm not a title provider per se, whatever. I'm just going out of knowledge and experience. That's all. I'm talking out of knowledge and experience. Things change state to state, situation to situation, y'all. I'm just going out of my knowledge, my experiences, and things per se. But and in that situation, if we were going by what they were saying here, without all that messiness going on, where it says like if the house is passed down to many children and the children pass away, then it's like it says, ownership is fractured and may continue to divide as the original beneficiaries pass away. Basically, stating that let's say if your parents left the house to their 5 kids and all their 5 kids have 2 kids, if one of those children pass away, then when you sell the property, that interest of that child then goes to their children. So that's all it's saying. It's just breaking. It's fractured, but it's breaking in almost like a branch, like a tree branch, where it's like branching off in different directions. So in Louisiana, it goes to the children first unless there's a will. Wow, okay. See, that's what every state is different. Thank you, Eddie. I didn't even know that. Every state is different of how things pass. That's why I said, even though I'm giving like this information around probate and how things go and how things are structured, always talk to an attorney, a legal counsel in your state, because it can all be different. This is just information around probate in Georgia, but some of the information might be similar, but it differs too. And again, I always tell people we live in the United States of America, but I call it the divided states of America. The divided states of America, sorry, because every state has their own laws, their own rules, and so we're united, but we're divided as far as when it comes to legalities. So make sure you ain't driving in one state and speeding, because you might be able to get away with it in one state, but the next state is like, no, you go to jail. But anyway, this is kind of how it goes, how it does, how like they kind of put together how property says inheritance without a will. So this is like without a will. It says, so this is the property. Hopefully you can see this. This is the property. And it says the land is passed down without a will or deed to provide ownership. So then it's showing how it passes down. So this is the parents. This is their children. It passes down to the children. Each successive generation generally results in more heirs being added to the land inheritance. So then it's showing like this one right here didn't have a child. These 2 had children. So her portion, I guess, it just basically ends. So then it gets passed down to their children. Then it says the absence of the deed or will becomes more complicated. Sorry, not complacent, complicated. Oh, complacent, sorry. Yeah, I don't know. Let me know if I'm saying it right, y'all. I'll be reading. Sometimes I'll be knowing words, but then I forget. And then it says and grows by generation as time and people pass. So then you see right here that it looks like according to this chart, dad might have passed per se. Mom was still alive, so it kind of left the mom and went to them. And then it looked like they both had their own maybe children or something. I don't know. But it's showing how it passes without a will. It says without proof of ownership, it may become difficult for heirs to obtain federal benefits for farms and could also force partition sales by third parties. So that is how it kind of is passed in Georgia. Again, I'm gonna keep saying Georgia because, like I said, every state is different. All right, let's go to the next thing. But that's actually interesting, Eddie, as far as in Louisiana, that it goes to children first. That's really interesting. That's interesting. Wow. Hmm. Interesting. But that's what I say. It's always good. That's why I like doing these lives and people. We talk like before we have conversation because you learn more and more as you go. So I love. I'm like a information um junkie. Like I like to be informed and I like information. So that's just me personally. I like to read a lot and research a lot. So I should have been. Everybody always say I should have worked for the FBI. They're like, you need to work for the CIA or FBI because you like to be everybody. You like to read and be in everybody's business. I'm like, no, I just like research. And I just, but of course, the best research is experience too, though, right? Experience gives you the best research too, as well. Anyway, so it says it says the bottom line, make sure you have the property, you inherit placed in the names of all heirs. So it says, how do heirs get property placed in their names? Succession. If all the heirs agree that the home or other property should stay in the family, but they want to keep the house titled jointly in their names, they must open an estate in the probate court. If there are no debts in the estate and the heirs all agree about what to do with all the assets, including the heir property, they can file a petition for order declaring no administration necessary. All the heirs must consent to the petition. Once the probate court grants the petition, this allows the house to be transferred to the heirs without a probate administration. Having approved the petition, the probate judge will issue an order that will be recorded along with the petition in the real estate court. So basically, this is just saying right here that like we kind of talked about earlier, what Eddie said. I'm learning quite a bit today. Oh, well, thank you for staying on here learning with me. I appreciate it. But and I appreciate you. I'm learning from you as well. So hopefully, like I said, anybody watch playback, hopefully they'll learn as well. But I'm gonna keep this comment on the screen because I like this comment because again, in the state of Georgia, it passes differently. But I like that you said in Louisiana it goes to children. So, but anyway, what it's saying right here in this particular paragraph is basically saying that again, like we stated before, every will have to be probated in the state of Georgia, and I think I believe it's most states wills have to be probated, and everything has got to go through probate. And as what it states here is that if the will is structured correctly, everything's in place, is laid out by the person who owns that property in regards to what they wanted the will to, what they wanted to happen when they passed instead of will, then you have to take the will down to probate court, and everybody's in agreement to what the person put in said will to play out accordingly. Then they'll have to just file a petition for right here where it says in Georgia they will file a petition for order declaring no administration necessary. So you don't need to go after this is done. It could be a quick process per se. Won't take as long as once you kind of go through the probate situation. Just go down there. Everybody's in agreement. We're good to go. Let's put this petition declare this order. No administration necessary. Like, we don't need nobody to oversee how we effectively go through this process of administrating and executing the sale of a house per se. We are in agreement that mom put on the deed. On the will. Devon will be the one. He is the executor of the estate. He also will be the one in charge of executing any sales, and effectively distributing any funds or any items per se. And we trust this particular family member, and we're good. Probate, sign everything off. Walk out the door. However, again, like we stated earlier, you can go in there and mom can say Devon's in charge of everything. You have three other siblings saying, no, I don't want you. No, you're not in charge. I'm in charge. No, I'm older. No, you old. In a whole situation, no one can get clarity around it. Probate person say, you know what? We're not declaring a petition for ordering to declare no administration necessary. You guys need administration over this, and we need to figure out who we're going to put in place to effectively be able to play out all the things in line as far as the will. So this is kind of what this is saying. If there's no argument, no one contests the will, we can declare said thing, and we can go about our day, and you guys can do what you want. Once you get, all the paperwork's in order. And if you do want to sell the house per se, they typically do it's a leave to sell, that they'll put in place too for you if you're if you're trying to sell the house. Like they'll be like, the executor, you have the right, give the leave to sell per se, to sell said property, distribute funds accordingly. It says to have your title to the property established, you may want to consult with an attorney. Like I keep telling everybody, please talk to an attorney. Just a realtor, consult with an attorney. The lawyer will need these documents, which can be obtained at the Fulton County Clerk's office. So this is in Fulton County. Again, Atlanta falls within Fulton County. In Georgia, we have several counties. I think we have down here 100. Is it 159 counties or is it 195 counties? I feel like 159. I don't know. We have a lot of counties in Georgia. I feel like Georgia is a few other states that have a lot of counties, but a lot of counties down here in Georgia. We have too many daggone counties. But I live in Cobb County, which is right next to Fulton County, which is only where I live at. I'm only like 15 minutes from downtown Atlanta. However, you have Fulton, Cobb, that's kind of, so Fulton's in the middle, which is where Atlanta is at, Fulton County. Then you have several counties around it. You have Cobb, you have Gwinnett, you have DeKalb. No, sorry, not Gwinnett. You have Cobb, DeKalb. I think Gwinnett kind of never doesn't touch it because Fulton goes up. Fulton goes up to Roswell can still be in Fulton, and then that kind of touches Gwinnett. So no. Well, no, yeah. So yeah, Cobb, Gwinnett, DeKalb, Clayton, and what other counties around Fulton? I think those are the only counties. But if anybody else is in Georgia, you remember the other counties, put it below. But yeah, we have several counties, but we have a lot of counties there. But anyway, this is about Atlanta, Fulton County. This is their probate system. Blah blah. And it says right here, please note your attorney may be able to access the documents online at the gscca.org. So that is an online website that we have down here. I always access it all the time because, again, I'm nosy. So on this website, you can access people's deeds. You can access title information. You can access, like, I look at people got liens against their properties. Like what's it called down here? The FIFA or something like that. I go in depth. I'll be like researching a lot. I'm like, yeah, so. Anyway, you can access all those things. So the clerks of Superior Court across Georgia have created a system that provides access to deeds and property transaction information to the business community, the land records of search of Georgia's. Oh yeah, 159 counties. We got 159. I know it was like 159, 195. It was. I knew 159 was in it. Counties are available 24/7. 7 days a week on the website. And then you can also, if you want to, like I used to do back in the day, I would go down to the courthouse and you can go to the courthouse as well. And access it, go to deed title and what is it called? The Office of Deeds and Title Records, or is the Office of Records and Title, something like that. But it's on Prior. If you're going for Fulton County, Atlanta, it's on Prior Street. So you definitely can go, and it's in the basement. Here are the documents required to get property title in your name. So this is what they're saying. If you want to get the property title in your name, you'll need these documents. A copy of the last recorded deed to the property, a list of the living and deceased heirs, including the dates of death or death certificates of deceased heirs, copies of wills or probate documents of the original owner and any of the person's deceased heirs, copies of written agreements among family members or persons outside the family regarding the property, copies of legal notices relating to the property, such as tax sale, foreclosure, pending, or threatening lawsuits and code violations. So you kind of want all these things to try to get everything, the properties, as it says right here, to get the property title in your name. It says taxes. So this is a conversation that I like to have with people. And this is a conversation I've been trying to get to have with this one client I'm working with that has gone through the probate, because she hasn't done it and she don't know that I know this, because again, like I said, I'm Inspector Gadget and I need to see what's going on at all times. And when you work in real estate, I get it. Everybody doesn't want to be transparent of what's going on. So because of that, I have to become Inspector Gadget, CIA, RoboCop, Arnold Schwarzenegger. So that's kind of, read this first and then I'll tell you, what could possibly happen outside of what they say here. So it says, taxes. As co-owners of property, each heir has an equal obligation to pay the property taxes. Paying the taxes does not entitle anyone to a greater degree of ownership than any other co-owner. Fulton County, again, this is pertaining to Fulton County down here in Georgia, has a homestead exemption that allows homeowners to pay a lower amount in taxes on the property that is their primary residence. So I want to say this again, primary residence, because this is a situation with a person that I'm working with now that they don't realize that I realized because I went inside, one, they are paying the property taxes. They probably don't know that I know this because I went into the tax assessor system, looked up the property taxes to make sure they are being paid because the house has been sitting for a while and they're just trying to figure out what they kind of want to do. We've been in several conversations, but the problem is that this person lives in another state and the whole thing of getting over here sometimes is kind of hard for them. But property taxes have to, you want to continue to pay property taxes even if you don't live in say home, because you don't want the house to foreclose on due to tax purposes, right? So I saw that the taxes have been paid up down. Different counties do the taxes down differently. Some counties you can pay the county and city tax comes in one, or some counties down here they come separately. So I saw that the taxes were paid up. So I was like, perfect. The taxes are good. We won't run into any of these roadblocks when it comes to pay taxes. However, what I saw too, and I'm like, oh, this is gonna be a problem. I'm gonna talk about it after this. Fulton County has a homestead exemption that allows homeowners to blah, blah, blah. We read that already. Again, that's around primary residence. However, only the person named on the deed can claim a homestead exemption. If the owner who passed away had a homestead exemption, that might drop off the following year, making the tax bill much higher. It says, warning about unpaid taxes. If no one pays the tax bill, eventually the property might be subjected to a tax sale, which can result in foreclosure. Note that tax bills and foreclosure notices are sent to the person whose name is on the property is in, which means that the notices for heirs properties may be sent to a person who is deceased. If no one is retrieving the mail at the house or property, the co-owners of the heirs property may not receive notice of the tax sale before the property is foreclosed on. So it says you can visit the tax assessed office in the county of the property to get tax information. So in regards to this right here, so let me see, I'm gonna pull up the next one too. But in regards to that, when it comes to the taxes, so again, when you pass away, when a person passes away, a lot of people like to live in people's houses, which is okay. I get it. Mom left you a house, dad left you a house, it's paid off. If you don't understand how real estate works, and if you never owned a house per se too, because most people, you might think like, oh, the house is paid off, because people tell me this all the time, and I got to tell them, no. But you might be like, oh, the house is paid off. There's no mortgage on the house, so I'm good. However, once you pay a mortgage off, you're always on this earth until something changes wise in America, you will always pay property taxes for the rest of your life. And then also, it's always great to have home insurance on a house. Do you need to have home insurance on a house? This is something that we'll talk to too with the home insurance provider coming on Sunday. You need to have home insurance on your house if you don't have a mortgage. To my knowledge, it's no. However, people say something different. But however, it's smart to have it on your house in case anything happens, because you never know what can occur, right? So let's just say for the rest of your life, you'll have property taxes and possibly home insurance. If you're in an HOA community, you'll have HOA fees for the rest of your life, even if your mortgage is paid off. So what I encounter is some people realize, they'll be like, oh, I got left the house. They don't realize that they still have property taxes they have to pay. They allow the property taxes to go basically to go kind of, I don't say domicile, but they basically allow the property taxes just to not be paid. And then they end up with a tax sale foreclosure situation. And I'm like, what's going on? You guys have to make sure you pay your property taxes. Outside of that, if someone passes away, make sure those taxes are paid. Outside of that, if you do not live in this house as a homeowner occupier, which I'm seeing with the client that we're trying to work together, you cannot have a homestead exemption on said house. If you own another house and you live in that house and you claim a homestead exemption on that house, every state might be different. But in the state of Georgia, because I don't know what every state does, state of Georgia, you cannot have another house that you are homeowner occupying that you live in, like the homestead exemption on, and then try to do another one a homestead exemption in a house you do not live in. That is illegal, it's unlawful, and you can go to jail in the state of Georgia. Okay? Even though I always tell people Georgia is the run amok state, it's the run amok state where they will put you in jail as quickly as you ran that muck. Okay? So anything down here in the state of Georgia, they will throw you in jail. Even if people don't know, I feel like I've done a lot in my life, but I used to also go into juvenile detention centers, and I would do arts programs and reading programs with juveniles that are incarcerated. And when I moved down to Georgia, because I used to do it up in North a lot, and I would be in these, these facilities with youth that had murdered people and, gangs and all these people or whatever. We would do like these reading programs and arts programs that I put together through my company. And when I moved to Georgia, I went and I did a program with a volunteer group at the Gainesville Juvenile Detention Center. So if anybody's from Gainesville that works at Juvenile Detention Center, hey, how you doing? It's been a while, but hey, how you doing? Anyway, when I was in there, one of the boys told me that, they were like, oh, well, do you work in this area? I said, yeah, I do. Through my company, we do, programs in which we go into the Juvenile Detention Center and we provide literacy, arts things for kids, because we want to make, because a lot of some of these kids that are in these positions, when you start looking at the data, doing research and everything, it kind of sometimes might stem not only from environment per se, but also from the situation of, the learning things and reading stuff and all those different things, right? So in regards to that, the young man was like, he was like, well, who other juvenile detention centers you've been in? What juveniles have been in centers? I'm like, well, I come from centers where people have murdered people, and so they were like scared. I'm like, why are you scared? They're like, you've been around people who kill people. I'm not glamorizing people being killed, y'all. Please don't think that way. But what I'm trying to say is that he was like, well, I'm in here because I just threw a rock at a window, and this is in Georgia. So like, it probably was more offensive outside of that, but that's what he told me. So down here, you can get arrested for anything. So try to keep the stuff, aligned correctly. In Jersey, Governor Chris Christie can do a whole bridge gate situation and get off and lay on the beach somewhere. Down here, you can't do that. So it's different in different states, y'all. And people know which states to run amok in. I'll tell you that. But anyway, let's get back to what we talk about in regards to why I was saying that. But I was saying that just because this particular person, there's still a homestead exemption on this house. And so that means the taxes are actually different. They're frozen. They're exempt because somebody's quote unquote homeowner occupying the house. No one is doing that. This person actually owns a property somewhere else. There's still a homestead over here. So what's going to happen, because this happened to actually one of my colleagues, what's going to happen is once they discover that the property, or even when you try to go sell the property, the county, at the closing table down here in Georgia, we close with attorneys. They will take the money out that's owed to the properties, the difference. So if you have a homestead from the last person and no one's occupying that space, any exemptions, any senior exemptions, any school exemptions that are placed on that property due to that person lived there before they passed away, and none of that has been cleared up, and you have not transferred property over correctly and cleared everything up, those taxes will then come out when you go to close your house. So you might have thought you got away, you might have thought you pulled a quick one. No. So make sure you get those taxes done. All right, let's get this done, because I'm still talking and we need to get through this, y'all. It says tangled titles. Most often, tangled titles happen when a homeowner dies without a will. As a result, children or grandchildren may live in a deceased relative's home without ever transferring the deed to their name. Generational wealth is key to long-term prosperity, and homeownership is often a critical part of building, maintaining, and transferring its benefits. There are several ways that heirs can resolve a tangled title. Families can decide to transfer the deed to one person's name, split the property between multiple people, or form a cooperative. This can be expensive, but it doesn't have to be. In addition to the cost, this process is often slow and setbacks are common, requiring genealogy records and other references that are challenging barriers for many people. So you have to kind of go through, they basically have to search. And this is what we're talking about as far as someone having to search. It says, what do I need to meet with an attorney. To save time when meeting with an attorney, there is some information you should gather beforehand: a copy of the last recorded deed of the property, a list of the living and deceased heirs, including death dates for deceased heirs, copies of wills or probate documents for the original owner of any of his or her deceased heirs, copies of written agreements among family members or within third parties regarding the property, copies of any legal notices relating to the property, such as tax sale, foreclosure, pending or threatening lawsuits, and quota violations. Let's move up here, you guys, real quick. Says we want to keep the family home. So this is what they're saying: if you want to keep the family home, what if the heirs do nothing? If no one, heir, creditor, or an interest party ever files paperwork in probate court to have an administrator appointed, then title to the house remains titled in the original deceased owners as of the date of death. However, ownership of the house is vested in the deceased owner's heirs until an administrator is appointed. It says, in this instance, there is no recorded deed showing a transfer of the house to the heirs. The heirs legally co-own the house, but there is nothing in the real estate records that documents that. Basically, if the heirs want some form of recorded evidence of their ownership of the house, then they can sign and file affidavits of descendant in the real estate records of the county in which the house sits. It doesn't change ownership because ownership is vested in the heirs. It changes evidence of ownership, but it may allow the heirs to qualify for programs that require proof of ownership. So it's basically, they're basically saying like it's good if you can, you don't have to. In the state of Georgia again, in the county of Fulton, you don't have to get the house deeded per se in your name, because once it goes to probate, that's all on record per se. But it's saying if you want to kind of take some type of take interest in like any programs that are provided to homeowners or ownership of said property, then they would have to have proof that you are the owner of said property. However, even if you are the owner of that property, what they're kind of saying here too is that because you guys went through probate and everything was put accordingly, that even if you own said property, that still doesn't create a break as far as the equal ownership that everybody has in property. It just creates proof that you're now on said deed per se of the house, but then they can qualify for these programs. It says keeping up with mortgage payment. It says when at the time of death a deceased owner was current on the mortgage payments, it is possible for potential heirs, family members, or others with an interest in the home to continue making mortgage payments if possible. The mortgage servicer is unlikely to care who makes a payment and may not even know the homeowner is deceased. So most times the mortgagors, and I know they probably don't want to hear this, so they discover this video. Hopefully they don't start looking at people's business. But most time a mortgagor is just worrying about the payment coming in. As long as the payments are continuously being made, they're not going to really check to who's making the payments, because they might not even know that the person passed away, because if the payments are still coming in and it's still coming through like the same accounts or same things, they're like, well, they just look at it as it's being paid, right? However, it can become a problem if you decide to, if that stuff might come to an end. It says there is no requirement that a mortgage is paid by the person listed on the deed. It says when property is transferred because of death, the mortgage lender may not exercise a due on sale clause. The heirs have the option to simply keep paying the existing mortgage. However, they will not have an ownership or security interest in the property. So that's that. We will head over to number 6. If you guys have any questions or want more information, just let me know. We're going to try to get through the rest of this because I'm talking a lot, so it's making it longer. So I'm going to try to get through the rest of this quicker. But definitely thank you for joining me today. If you're watching this if you're a replay game, watching this on a replay, please put in the comments, how you came onto the channel, where you're watching from. If you need any assistance in probate, if you have questions, you can reach out. But I always tell people, please talk to an attorney first. But again, just talking about this stuff because it's something that I've personally am either gone through, went through, or I know colleagues that went through situations. So I'm always on the phone talking to people about this stuff. So why not do live about it? All right, obtaining a mortgage modification for heirs property. So people don't know this, but you can obtain a loan modification, but you have to do it has to be done in such a way. So I'll read through it real quick. So if you still owe payments on the house, right? If someone still owes payments on the house, can't effectively pay, they might want to modify said loan, right? Sometime prior to the death, the descendant may have fallen behind on mortgage payments, and the owner's death may have exacerbated, sorry, we having time, y'all, have exacerbated the family's financial hardship such that heirs are not able to bring the loan current. Heirs may wish to apply for a loan modification if the loan is owned by Fannie Mae or Freddie Mac or insured by FHA, VA, or USDA. Applicable investor rules typically allow for spontaneous loan modification and assumption by an occupant heir. One second. By occupant heir, my sister tried to, sorry. Loan modification rules that apply to most residential mortgages, including Fannie Mae, Freddie Mac, FHA rules, require a confirmed successor and interest after a death or divorce to be evaluated for a modification under the same rules that would apply to the borrower. If they qualify for the modification based on documentation or documented household income, the servicer might approve the successor for a spontaneous, not spontaneous, Lord Jesus. Why am I just said it and then I'm having trouble. So we're gonna go by it because I'm having brain farts now. I'm looking out the window, I'm like, is this snowing again? Loan modification assumption of the prior owner mortgage loan. It is more difficult to obtain a loan modification when an heir can yet provide their ownership status due to a pending or yet filed probate case. If an executor or administrator has been appointed by the probate court, the person can press for a loan modification. So some courts hold that an executor or their representative of the borrower estate may pursue a RESPA claim on behalf of the deceased borrower's failure to offer a loan modification. So this is in regards to any loan modification. Again, if the person fell behind in the mortgage, you obtain said property. There is a procedures you have to go through, eligibility, you have to require fees per se, but you can definitely get a loan modification. It says clearing title. So we kind of talked about this earlier. Says for heirs title property. Again, this is in the state of Georgia, you guys. So I just want to clarify, Georgia, every state is different. However, some things might be similar across all states, which basically, if you have a will in place, you still have to go through probate. Basically, all states require you to go through probate. As far as I know, I think every state requires it. But definitely talk with an estate planning attorney or a probate attorney, right? Clearing title for heirs property. If all the heirs agree that the house should stay in the family, but they want to keep the house title jointly in their names, they must open an estate in the probate court. Once appointed, the executor or administrator can execute a deed to transfer title to the heirs or beneficiaries of the estate. If there are no debts in the estate and the heirs are all agreed about what to do with the assets, including the heirs' property, they can file a petition, which you talked about earlier, for ordering, declaring no administration necessary. We don't need nobody to administrate how we, sell the house or keep the house or whatever. This is what we're doing according to the will. All the heirs must consent to that petition. Once the probate court grants the petition, this allows the house to be transferred to the heirs without a probate administration. The petition and the order will be recorded in the real estate records and serve as evidence of the heirs' ownership of the house. So again, this is probate around a will, right? If there's no will in place, you will be going through all this because they have to search. The court system will have to then search records to find who are the heirs of the property. So it can get a little messy, y'all. Like Eddie said earlier, what he said right here, he said that causes a mess. He said sometimes they can't find all the family members that cause a mess. So yes, it can cause a mess. Rights and responsibilities when the multiple heirs decide to keep their property. When more than one person co-owns property together, each heir has an equal right to use the property as well as equal responsibilities of ownership. This is true regardless of who is actually living on the property. So it don't matter if your one sister got the property and she lived on the property, you still have rights to equally you still have rights to equally have access to said property and different things or whatever. Because you guys all own the property. This is true regardless of who actually living on property, who's taking care of the property, who is paying the bills, etc. All the heirs are legally equal as co-owners and equally liable for any utilities, properties, and mortgage payments. All right. So let's go on to the next part of this. We're almost done, you guys. We're almost done. We have 9 pages. We're on number 7. Stick in here with me. Stick in here with me. I just wanted to give you guys as much information I can give you around this probate. Again, this is Georgia. Every state is different. I just want to clarify that. But there are some similarities in the probate process, right? So right here, it says selling the family home. In order to change the legal ownership of the home, the heirs must file a petition in probate court. The type of petition will depend on whether the deceased has a valid will. If there is a will and the heirs have the original document, they can file a petition to probate in will styling form. If there is no will, they can file a petition for letters of administration. Once the petition is granted, letters of testamentary are issued to the executor of or the administrator, and the title to the property is vested in the person until they consent to vest it back to the heirs or others. It's a mess. It's a mess. Let's see. Oh, hey, what's going on, Proud Liberal? 24. It says it can be a hot mess. I know of some family disputes over properties that were never resolved. They abandoned the properties. Oh wow. So if they abandoned the properties, with them abandoning the properties, did anything happen in regards to like tax sales, as far as like the city forcing foreclosure to tax sales? Because even if the property is in place, there is still taxes that need to be paid on it, even if the home has a paid off mortgage, or even if the home had a mortgage, they end up having to go to foreclosure. It sucks when you can't figure out come to a clarity when your family members about property, and having to basically the state takes it. The state takes it, and it sucks. Basically, it's crazy. And I think too. Well, I know in Georgia, I think once it's sold, I forget. I think it's once it's sold down here for tax purposes. If there's any overage in the amount of tax that were owed to the property, whatever is over the amount, if you as a person, if you know that own the house, say the taxes were $10,000 on the house, but they bid at the tax office $20,000, that you as a person, if that was your house, and if you know the difference, if you know what they bid for, you can actually get the difference of the taxes, of the money left from the taxes. I don't know, it's something like that down here. In my case, it was in a foreign country, so the property sits vacant. Not sure about tax laws overseas. Oh, okay. Wow, that's interesting. Yeah, I'm like, that's interesting to see. And unfortunately, in America, they take it. But it's interesting that because I do know in Africa, because I have a lot of friends that are from Africa or live in Africa. Because most people don't know this. When I lived overseas in Europe, and when I lived overseas in Europe, right outside of England in North Hampshire, right outside of London, I mean. I met a lot of friends who, came from Africa, and a lot of Africans, even though I'm African American, have descendants, African lineage per se. However, I met a lot of people who came, from the continent per se of Africa and over in England, and they would tell me how there's no, taxes on the land. I was like, oh, why can't we do that in America? But we're a capitalist country in America, right? My wife is from Vietnam. Oh wow, okay, wow, okay, wow. Well, at least the property hasn't been taken. At least you guys have the property there. It sucks that it's abandoned, but hopefully in the future, might be able to go back, fix it up some way somehow, and still have your property. That's that can be a blessing in some way. It's a mess when it comes to family dispute, but it's a blessing that it's not being taken per se in regards to the states and the counties per se taking, the property due to taxes per se. But wow, that's pretty cool. Your wife is from Vietnam. Wow. I have like I said, a lot of my families are from different places. My one aunt, she's from the Philippines. My grandmom was Dominican. She came to went to Puerto Rico, then came to America. My grandpop is African, descendants, lineage per se. His family was brought over from Africa, and he was born in South Carolina and worked in the fields and all that stuff or whatever. So I just love, when you get to know people, make sure people, but let me get back to this because I don't want to keep y'all all day. And when people are trying to, replay this thing, I'm like, this boy talks too much and it's too long. So it says some heirs keep, some heirs sell. Sometimes some of the heirs want to keep the house, but others want to sell their share. For the buyout option to work, all the heirs should agree what the fair market value of the house is, what each selling heir should get from their share, for their share. That the keeping heirs will buy the shares of the selling heirs, that the selling heirs will sign quitclaim deeds to keeping the heir in or to the estate, to have an administrator sign and record an administrator's deed of asset in favor of keeping heirs, that the heirs will pay debts of the estate if other estate funds are not available, and that the heirs will pay the cost of administrating the estate if other estate funds are not available. The buyout option is tricky and is more complicated than it seems. So yeah, so people, if you you definitely can buy, your family, your shares person or your interest in the property. You definitely can buy it out, but you gotta be able to pay it out, because that's only you're gonna be able to, you can do it. All right, so we're almost finished, you guys. Almost finished. Hopefully, this is valuable information. But that's interesting. That's interesting as far as the countries. But every country is different. We're in America. This is a capitalist country, y'all. Family sale option: one family member buys the house. If a single heir or other family member can afford to buy the house, the other heirs may wish to sell that to the person keeping the house in the family. For the family sale option, all the heirs should accept the family member's offer to purchase the home. 2, have the administrator file a petition for leave to sell. So yes, I mentioned this earlier, where you have the petition that they have down here for the leave to sell real estate, and ideally have signed consent form from all the heirs. Then, if the probate court grants the petition, the administrator will hire a closing attorney and transfer the house by administrator's deed of assent to the family buyer. The administrator will then complete administration of the estate and distribute the proceeds to all the heirs. So if you guys don't know, that people always ask me this question too, like, do you need a realtor? I don't know, it might be blurring. It's kind of blurring. Do you need a realtor to sell your property when you have, like, you're going through probate? You don't. You can have your executor or your administrator per se. They can help sell the house. Is it smart to do that? No, but we'll read it right here so you guys know. Open market option: selling the house even if some heirs disagree. So this is basically saying if there is no one can come to an agreement on selling the house per se, or in regards to the estate, that they'll put an administrator in place, and when the administrator is put in place, the administrator will execute the sale of the house. So they'll basically force to sell your house. So even if some people want to keep it, some people want to sell it, they'll just force to sell. In the state of Georgia, let me make that clear again. The state of Georgia, and in the county of Florida. If no family member can afford to purchase the house, or if the heirs can't agree, then an administrator may be able to sell the house on the open market. This option can also be used if the heirs cannot agree. Although it will be easier and faster if they do. The steps for the open market option are: 1, the administrator lists the house for sale with or without a realtor. 2, anyone makes an offer, whether a family member or not. 3, the administrator accepts whatever offer is the highest and the best. 4, the administrator files a petition for leave to sell real property, ideally with signed consent from all the heirs. If the probate court grants the petition, the administrator will hire a closing attorney and transfer the house by administrator's deed of assent to the buyer. The administrator will then complete administration of the estate and distribute the proceeds to all the heirs. So yeah, so the administrator can sell the house. And then we'll go to this last page, and then we'll have a little bit more information now. Jump off here. So this page will give you, it's like a question page, but it'll also give you some resources if you're in the state of Georgia. Every state probably does have resources in regards to helping people out when it comes to probate, anything. And again, I thought I tell people, like, reach out to people around you, not even just realtors, any type of professionals, and just people in general, because you don't know what people go through, so you don't know what people know. So I always tell people the purpose of us all being here together on this earth, we all come with a wealth of knowledge. We all come with so many experiences that we live throughout life. So just because you feel like you don't know, I'm pretty sure it's someone to your left or you're like in your family across the street somewhere, a friend or whatever, that probably knows some information or could give you some insight to something that can lead you down a right road somewhere. So you should always ask questions. So right here, this is basically saying like making the decisions to divide inherited real estate. The executor or administrator of the estate will have the responsibility of distributing assets accordingly to the terms of the will, which we kind of talked about by the Georgia law. For example, if the will states that each beneficiary receives an equal part of the property, the executor will sell the house and split the profits equally between each beneficiary. Sometimes the beneficiaries will receive deferring portions of the estate after accounting for certain expenses and commissions. For example, one beneficiary might receive 40%, while the other two heirs might get 30%. The heirs will receive the allocation based on what's left in the estate after expenses such as final bills, real estate agent fees, maintenance, as well as reimbursements to any heir or beneficiary who had to cover any expenses of the estate pending the appointment of the administrator. Remember, we talked about this earlier. Like he said, gotta go. All right, Eddie, talk to you later. He said, gotta go to a meeting. See you soon. See you soon, Eddie. I'll see you guys on Sunday. Take care. Have a wonderful meeting. Thanks for joining me. I appreciate it. Thank you. It says, can majority rule when dividing inherited real estate? Though it seems fair and logical, majority doesn't always rule when splitting inherited property. The executor is in control of how the will is carried out and will usually have the final word on how to split real estate assets. In some cases, however, the court may ultimately decide how a probate case proceeds. The executor must follow the will unless all beneficiaries agree otherwise, and if executor agrees, the court authorizes with a change from the will. So let's go down here to the last part. So this part right here is, do you need a realtor to sell a property? You don't need a realtor. However, it's saying while you can technically sell a home without the help of a real estate agent, it is a good idea. It is not a good idea. Selling an inherited property is more complicated than typical home sale requires unique expertise and attention. Working with a real estate agent that is experienced in probate and inherited properties will give you the best experience and so on. And then right here, this kind of gives you some resources per se. Again, this is from the this is for Georgia. This is Fulton County. Every county might have different resources. So you definitely want to check into your county, go down to your probate court and ask them if they might have any resources that you can acquire going through this probate process. It says real estate fraud is concern for all property owners. So we do have a thing down here where there's a lot of real estate fraud, a lot of deed fraud down here. And I got to make a video too talking about the they just put a thing down here in law for deed situations. Here are some resources: Atlanta Legal Aid Society that you can utilize. Georgia Heirs Property Law Center, Georgia Department of Revenue, search for unclaimed property. So you can search if there's any unclaimed property, you can search for it down here in Georgia in that website. National Association of Insurance Commissioners, Fulton County Tax Assessor. Like I like to go to their tax assessor. I like to go to everybody's county tax assessor. U.S. Department of Agriculture, National Association of Unclaimed Administrators. So those are some resources that you guys can look into when it comes to probate. Before we get out of here too, I want to just finish up by saying, if a person that you are currently with, if your sisters and your sister verbally says, I want you to have my house, and you currently have power of attorney over said person, you guys have to understand too that power of attorney dies when the person dies. So you cannot sell their assets if the person dies and say, and verbally says to you, I want you to sell my house. You can have my house, or you can sell my house when I pass away. And you're the power of attorney over that person, POA. Once the person passes away, power of attorney leaves as well. So you will have to go through probate, either whatever's placed in said will, or if there's no will in place. So I always say it's great that if you are the power of attorney over somebody, and if they do say they want you to have their house or sell their house, ask them to put a will in place, or something, something in place per se. And you definitely want to talk more with an attorney about this. Ask them to put a will in place that states that, because if not, they will have to, if the person will pass, if they have a house and they pass away, it will go in order to succession according to your state, your county, and the laws in that particular city, per se, the state, whatever. So make sure that's in place, because POA does not give you the right to sell a person's house after they died. If they're alive and you're selling a house, it does allow you to do so to help you out in that instance. But if they're passed away, POA does not give you the right to sell nobody's house. You have to go through probate. And the last thing that we want to kind of finish off with today is in regards to when it comes to probate. People say, well, where do I file a probate at? So to file a person's probate, you typically want to go to the probate court in the county where the deceased person either resided at the time of their death, or where it said property is at that you're probating. You want to go to that county for probate purposes. All right. So nonetheless, it was great you guys joining me today. Like I said, I came on here. This was an impromptu live. I'll be back on Sunday, every Sunday at 6:30 p.m. Unless something happens or something occurs as far as a holiday or different things happen. I'll be on there Sunday, 6:30 p.m. I typically like to come on after Christina Smallhorn, and I appreciate Eddie Smallhorn, Proud Liberal 24 today, coming on and joining me in discussion. Eddie and Christina, they are based out of Louisiana. They are wonderful. Christina's a wonderful real estate agent, and her husband helps her get a lot of information out to you guys in regards to real estate, education, and knowledge. So please go over and check their channel out, Christina Smallhorn. There's other wonderful agents too. If you're looking to be connected to an agent in your state, I can, do that for you if you would like. Jackie Baker out of New Jersey, you have, which is a wonderful real estate agent. You also have Jen Sylvester out of Massachusetts. You have David Matney out of Omaha. You have Joe Pareca, I believe that's how you say last name, out of California. So these are wonderful agent partners. They also have wonderful YouTube channels. So go check out their YouTube channels as well. Thank you again for joining me today. Do not forget to like and subscribe. Please subscribe to the channel. Please like the video, and please share it if you feel like this information is informative to anybody that's going through something similar. Again, this probate information was in regards to Georgia probate, also Fulton County probate. However, some of these information is similar across the board. So please pick out information that might be similar or helpful for you, but also talk to a local estate planning attorney or a real estate a probate attorney per se in regards to any additional information you may need. And also you can go down to your probate court, grab information from the probate court, and if so, possibly ask some questions, but they won't be able to guide you through the whole process because I don't think they're legally allowed to do that. However, you might be able to ask a question here and there like the clerks. All right. Anyway, have a wonderful Friday, great weekend. Take care if you're in the state of Georgia. Be safe out here in the snow weather. If you're in California, please, my heart goes out to anybody involved in wildfires. I have a lot of friends out there in California. They have all told me that they're safe. Be careful. Also, if you're in Texas, I know Texas had a situation down there too. One of my sisters live in Texas, so they're okay down there. Wherever you're at, if there's any disaster happening around the world, please be safe. Please be careful. And I will see you on Sunday at 6:30 p.m. as we will be joined by a home insurance agent. So if you have any questions around home insurance, please drop in the comments if you're watching this replay. And I'll see you Sunday at 6:30 p.m. Eastern time. Take care. Bye, y'all.